The question is that the bill be now read a second time. Mr. Murali Pillai.
Mr. Speaker, sir, I support the primary aims behind this bill as enunciated by the Honourable Second Minister for Home Affairs in her speech, especially the proposal to digitalise and automate immigration clearance. It is well known that, that our ICA officers, staff and auxiliary police officers deployed at our immigration checkpoints have heavy workloads. The Woodlands checkpoint ranks amongst the world's busiest border crossing with more than 350,000 people passing through every day. Just over the long weekend of the presidential elections from 31st August 2023 to 4th September 2023, more than 1.7 million people crossed Woodlands and Tuas checkpoints. These officers often make personal sacrifices to discharge their duties. Owing to the lean manpower situation, they frequently forego going on leave during school holidays, which coincides with the peak travel periods. This is so that fellow Singaporeans are not inconvenienced when they travel on holidays. They deserve our salute for steadfastly securing Singapore's borders and keeping us safe despite the significant challenges, some of which were enunciated by the Honourable Minister. With the manpower crunch that all sectors across Singapore face, it makes eminent sense to leverage on technology to ease the clearance process. The plans to implement automated and contactless clearance and the checkpoints without passport presentation are particularly welcome. Not only will these measures result in faster clearance, but they also improve the experience of travellers too. For these reasons, I fully support the provisions in the bill to implement the automated and contactless clearance process at checkpoints. Turning to the other objectives of the bill, I seek clarifications on three broad areas. First, the revised approach to sentencing when dealing with immigration offenders. I note that it is proposed that fines be introduced in lieu of an extended prison term for immigration offenders convicted of immigration offences and who are exempted from or found to be medically unfit for caning. On the face of it, the replacement of a prison term imposed in lieu of caning with fines instead of imprisonment alone may dilute the overall deterrent effect of the sentence. I understand that the policy reason for this is to reduce the state resources that would otherwise be committed when foreigners who cannot be caned have to serve longer imprisonment terms. In principle, I do not have an issue with the policy so long as the execution of this policy is carefully calibrated with other sentencing aims. My query is twofold. Why is this policy applicable to an offender convicted of an offence of employing 5 or more illegal immigrants under the proposed Section 557(1)(b) of the Act? Usually, such offenders being employers are likely to be Singapore residents. Hence, the policy precipitating this change on the face of it should not be applicable to this class of offenders. Next, why is there no provision in the bill to deal with the probability that the immigration offenders would not be able to pay the fine? I would imagine that most foreign immigration offenders would lack the means to pay fines. This is why they left their homes to come to Singapore to make money. If fine sentences are imposed in lieu of imprisonment over the inability to carry out a caning sentence, we would have to deal with the high probability that these offenders would not be able to pay the fine. In such a situation, since nothing is specifically proposed in this bill, Section 319 of the Criminal Procedure Code, CPC, would apply. This provision gives the court the power to impose an additional imprisonment term in default of the payment of fine. There is a scale under Section 319 of the CPC that determines the limit of the imprisonment terms. For offences punishable with a term of 24 months or more, the maximum imprisonment term cannot exceed half of the maximum term of imprisonment fixed for the offence. This is the upper limit of the scale. For offences punishable with imprisonment for a term less than 24 months, the maximum term imprisonment term cannot exceed 1/3 of the maximum term for imprisonment fixed for the offense. This is the lower limit of the scale. There are several offenses provided in the Immigration Act that are subject to caning, for which the upper limit under Section 319 of the CPC applies. And to illustrate that, if you were to look at Section 9 of the Act as it currently stands, which deals with an immigration offender which has already been issued with a prohibition order, if he were to come into Singapore again, then he may face an imprisonment term of not less than 2 years or not more than 5 years, and shall also be liable to be fined and caned. As mentioned by the Honourable Minister, if he's not medically fit to take caning, then the court can replace the caning sentence with an imprisonment term of not more than 12 months. But with the replacement of the caning with a fine sentence, by applying Section 319, because the punishment is more than 2 years, the upper limit of the scale would apply, in which case the default imprisonment term can go up to 2.5 years, which is more than the 12-month period for not receiving a caning sentence. In my respectful view, a simple provision in the amendment bill would have taken care of this, spelling out that a shorter imprisonment period or the lower limit or under Section 319 of the CPC may be imposed in situations where fines imposed in lieu of caning are not paid. May I ask the Honourable Minister, why is it not felt necessary to make this explicit in this amendment bill? I now turn to the next area. I would term this as an issue of fairness in dealing with foreigners. I note that it is proposed that statutory appeals to the Minister for Immigration decisions made by or on behalf of the Controller of Immigration be abrogated. In explaining this position, I note the Honourable Minister's point that entry into Singapore is really the prerogative of the government. I have no quarrel with that proposition. In addition, it is proposed that the current Section 8, subsection 4A, which requires the controller to inform a person the class of prohibited immigrants of which, in the opinion of the controller, the person is a member of, be also repealed. For the benefit of honourable members, there are 15 classes in the Immigration Act, ranging from a person who is believed to have no means of supporting himself or herself, or believed to be a prostitute, or believed to be a person who advocates the overthrow of the government by violence. Also, under the proposed Section 39B of the Act, it's provided that the controller is not required to give any person who may be affected by his decision an opportunity to be heard. Respectfully, I'm concerned about these proposals for the following reasons. First, from a values perspective, I disagree with the view that just because we are dealing with foreigners who should not expect the right of entry or stay in Singapore, we should deal with them summarily. In my respectful view, our immigration system should reflect the values we stand for as a nation. Granted, we do not owe non-Singaporeans the same duties and obligations we owe to ourselves, but foreigners should have the same recourse to justice as a matter of principle. And in this case, we owe them two specific duties as members of a common humanity. First, to deal with them fairly, to mandate that they not be told why they are labeled as prohibited immigrants, nor offer them an avenue to provide explanation does not, in my respectful view, fulfill this duty. Also, we must be mindful that a good number of foreigners which may be subject of action by the controller have spousal and familial relations with Singaporeans. Such affected Singaporeans would certainly expect that the system operates fairly for their spouses or relatives in dealing with immigration matters. As I said on the point of fairness, sauce for the goose is sauce for the gander. I would imagine if the roles were reversed, Singaporeans who are immigrants in other countries would expect to be dealt with fairly by foreign immigration authorities too. Second, a duty of due process. The current appeal process to the minister ensures that there will be no single point of failure from a system perspective. We should be mindful, it is proposed in this bill, that the controller be vested with even more powers. As was explained by the Honourable Minister, one example is the No Boarding Directive, to deny foreigners from boarding from places of embarkation, even as transit travelers. Just by having an appeal process alone, we will ensure system-wise that the controller will use his powers carefully and with circumspection. By having an appeal process, the minister would be able to have access to all relevant facts of the case and to make his own decision on the merits of the case. This is opposed to a mere administrative review of the minister on the basis that the ICA comes under his charge. He's well capable of handling sensitive factors and information too. In fact, this is the rationale for providing the statutory appeal to the minister instead of the court, which is ordinarily accessible by members of the public as well as the press. Finally, I'm not privy to any information that suggests that the current system is broken. I do appreciate that the government must be pragmatic in dealing with immigration matters. However, unlike some countries which deal with immigration matters through digital system and have a backlog of cases to handle, I do not think a similar situation exists in Singapore. Hence, the question arises, if it ain't broken, why fix it? I would also like to point out, as a matter of comparative law, countries such as Malaysia and Brunei, which have a similar history and have similar pieces of legislation as our Immigration Act, still retain the statutory appeal to the equivalent of our minister. I'll be grateful for the Honourable Minister's explanation to my concerns. Finally, I turn to my last area, operational matters. For this, I wish to raise 2 points. First, on the proposal to allow immigration officers to collect advanced passenger information, I would like to inquire if it is proposed that public transport operators, such as the operator of the RTS link that is due to be commissioned in about 3 years' time, or SBS Transit that operates service number 170, will also have the obligation to collect API, or would they be exempt? The provisions in the bill as they stand are wide enough to include public transport operators. Should they apply, however, this may create practical problems and bottlenecks having regard to the huge number of train and bus commuters that the operators will be expected to handle on a daily basis. Second and finally, I note that it's proposed that the controller be vested with the power to temporarily restrain a child from leaving Singapore in compliance with a court order until the child's parent or legal guardian collects him or her. I support the proposal. I would like to make a suggestion in this regard. I understand from my professional colleagues who practice family law that in the usual case, the family court would order that a child be allowed to leave Singapore where the other parent provides his or her written consent. Such orders would then be served on ICA. ICA would then have to take on the obligation to operationalize the order by checking to see if the suitable person wanting to bring the child out of Singapore has the requisite written consent. I wonder if there's a scope to digitalize the entire process. This should cover both the notification of court orders as well as the lodgement of written consent with ICA. In this way, I believe you will gain more efficiency and reduce the risk of making mistakes too. Sir, in conclusion, let me iterate my support once again for the provisions in this bill aimed at equipping our men and women of the ICA with the necessary legal tools and teeth to effectively deal with the growing challenges that they face in carrying out their important task of securing our country's borders. I've carefully reviewed the proposed amendments in the bill dealing with sentencing policy in the Immigration Act. I do not believe they represent a derogation from our uncompromising stance against immigration offenders, as well as traffickers and harborers of illegal and prohibited immigrants. That the law will deal with them firmly by imprisonment, caning, or fine. It is important to maintain this tough stance so that we do not backslide to the situation several decades ago when we had a serious illegal immigrant problem that affected Singaporeans' safety and security. Mr. Speaker, sir, notwithstanding my concerns that I expressed in my speech, I support the bill. Thank you.